It is noon and let's get started. Welcome everyone to the New Civil Liberties Alliance Lunch and Law Series. I'm Adi Dynar. I'm Litigation Counsel at the New Civil Liberties Alliance. With us today to discuss the historic nomination of Judge Amy Coney Barrett to Justice Ruth Bader Ginsburg's seat on the US Supreme Court. We have two distinguished panelists with us. Professor Renee Knake Jefferson is a professor of law at the University of Houston Law Center, and she's also the Joanne and Larry Doherty Chair in Legal Ethics. She directs the Law Center Outcomes and Assessments team there. She teaches constitutional law, professional responsibility, and a seminar on gender, law, leadership, and power. She's the author of 3 casebooks. Her latest book, the most recent book, Shortlisted, Women in the Shadows of the Supreme Court, has been called an excellent contribution and essential for anyone who values diversity by the Library Journal and praised in numerous reviews. She has written over 20 scholarly articles, including publications in law reviews across the nation. She's a graduate of the University of Chicago Law School. Welcome, Renee.
Thank you so much for having me.
And our second distinguished panelist is Margaret Little. She's Senior Litigation Counsel at the New Civil Liberties Alliance, and she has over 3 decades of experience as a trial and appellate litigator. She has dealt with multiple complex areas of law and litigated cases, including in the United States Supreme Court. She is a graduate of Yale College and Yale Law School, where she was awarded the Potter Stewart Prize. She was a law clerk to Judge Ralph Winter of the United States Court of Appeals for the Second Circuit. Welcome, Peggy.
Thank you.
So for our members of the audience, welcome. We have a chat and Q&A feature in Zoom. So so we'll have a Q&A session towards the end of today's Lunch and Law discussion. So if you wish to ask questions, you can do it throughout the session today, and I'll take up the questions towards the end in the order in which we receive them. So with that, I wanted to begin with sort of a review of Judge Barrett's nomination, the historic nomination and confirmation hearings that we saw. For example, I mean, some of the credentials that she has are stellar and obvious. She has clerked with Judge Lawrence Silberman of the DC Circuit, and she has clerked with Justice Antonin Scalia on the US Supreme Court. She was nominated in 2017 to the 7th Circuit, and she received she was confirmed by the Senate by a 55-43 vote count in the Senate. I believe there were 3 Democratic senators who voted in support of her confirmation. Joe Donnelly from Indiana, Tim Kaine from Virginia, and Joe Manchin from West Virginia. And with them were 52 Republican senators. So in many respects, this is a historic nomination. If confirmed, Judge Barrett would be the 5th woman on the Supreme Court and the 14th associate justice to occupy the seat which was created in 1807 and first occupied by Justice Thomas Todd. So in many respects, this is a historic nomination and confirmation that we are seeing. So with that, Renee, I want to start first with you. I read your book Shortlisted with great interest, and I highly recommend the book to our audience. So tell us what you mean by shortlisted. What are some of the factors that went against some of these outstanding women jurists and lawyers that did not end up in a place where Judge Amy Coney Barrett is at the moment?
Sure. So Shortlisted started as a bit of a mystery to be solved. I did a media study with a colleague of mine about almost 10 years ago now. We were looking at the way Supreme Court nominees were discussed in the media from the 1970s through the confirmations of now Justices Sotomayor and Kagan. And in that, we were unpacking the very gendered coverage of women nominees to the court. In the thousands of newspaper articles we read, we looked at every article that appeared in the Washington Post and the New York Times that discussed a nominee to the court. We found an article written in 1971. It was about Richard Nixon's shortlist. There were 6 names. Recall, this is when Nixon was facing 2 vacancies on the court. He ultimately would fill them with Chief Justice Rehnquist and Justice Powell. But his shortlist had 6 names, and there were 2 women, Mildred Lilly and Sylvia Bacon. Now, the New York Times discussion of their qualifications included things like saying that Mildred Lilly had maintained her bathing beauty figure even in her 50s. So of course, this article fit into the thesis of our media study, but that's not really why it was so interesting to me. I was like, who's Mildred Lilly and who's Sylvia Bacon? Why had I never heard of these women before in a high school history class, let alone in any context as a law student? And I wondered, well, how many other women were shortlisted for the US Supreme Court before Sandra Day O'Connor became the first? Of course, she was nominated by President Reagan in 1981. He was delivering his campaign promise to put a woman on the court, and he did. And that's really the history that I've known. I think that's the history that, to the extent the country is paying attention to who our Supreme Court justices are, that's the history we know. And the book Shortlisted is really what we found when we set out to answer that question. Were there other women who had been considered for the court before O'Connor, besides these 2 on Nixon's list? So the answer to that is that there were 9 women, and I promise you we didn't try to find a whole Supreme Court filled of women, but we ended up with 9. The criteria was looking for some sort of official way that they appeared on a president's shortlist. Before President Trump, trying to figure out who's on the shortlist was very difficult. We can now obviously go to whitehouse.gov and see his, well, not so shortlist now, but his shortlist. We combed through presidential archives across the country. We looked at news accounts, 9 women going all the way back to the 1930s. Florence Allen was the first woman to appear on a president's shortlist. One of my favorite discoveries in a presidential archive is the memo that was prepared for FDR in 1937. That year might ring a bell for everyone. He was contemplating putting some more justices on the court at the time. He had a list prepared, a long list of men's names, and Florence Allen appeared there. At the time, she was on the Sixth Circuit Court of Appeals. So the first half of the book tells her story and the 9 other women who were considered before O'Connor. The second half of the book really identifies lessons to be learned from their lives that I think have a lot of modern resonance today. And again, not necessarily something I set out to tell in writing this book, but once I uncovered their stories, could not go on to think about how the way they carved out their paths in legal careers really has a lot to offer as we look at a legal profession that, even though women have been entering in numbers equal to men for decades, the leadership roles don't reflect that diversity. And so that's the second half of the book. And it, importantly, to go back to your question, what's the shortlist? What do I mean by shortlisted? So on the one hand, to be sure, to be selected, you got to get on the short list. But one phenomenon that we observed in this research again and again for these incredibly qualified women is that they found themselves shortlisted in the sense that their name was placed on a president's list to suggest a priority or at least caring about diversity and equality. But because they remained on the short list, the status quo was preserved. And that's really a phenomenon that doesn't just apply to the US Supreme Court shortlist, but is something that we see in all areas of professional life. And so that's the story Shortlisted tells, and also the goal in its conclusion, offering strategies to combat that phenomenon of being shortlisted.
Thank you, Renee. I want to come back to the strategies that you discussed in the second half of our discussion. So hopefully, I want to have your thoughts on the strategy. It's pretty interesting, the kind of 8 suggestions that you have mentioned in the book. But before I do that, Peggy, I want to get to you with the following. So in all of these candidates that Renee talks about in the book, they have stellar credentials. They have really achieved a lot of things as jurists, as lawyers. So I want to focus on Judge Barrett's credentials and her written record. and Peggy, you have studied her writings in detail, and you have reviewed them recently, and you have talked about them. So tell us about some of Judge Barrett's decisions and how that reflects on her judicial temperament as a Justice Barrett.
Thanks, Adi. I'd be happy to. Her opinions are really standout opinions. They, when you read them, you get a sense of energy, a sense of commitment, depth. She is not going to leave any stone unturned, attention to detail. And it doesn't matter whether it's a large case or a small one. I read through a number of Social Security's appeals, which is probably not a judge's favorite thing to do since it only matters to the particular person before them, but it matters a great deal for that person. It's everything. And the depth and attention to detail she paid in those cases, not at all afraid to reverse an ALJ who had been sloppy or had made medical assumptions that were not substantiated by the record. She unhesitatingly reversed those opinions. In her big opinions as well, especially if she's tackling a new area, you see her dive in with energy, enthusiasm. A friend of mine, Walter Olson, who's a pretty well-known legal commentator, I think he either tweeted or is on some social media, he expressed the same sense that he was going through her writings and her opinions and could see why she was praised in such glowing terms, because this is standout legal writing and the kind of thing that does elevate one judge just, from the ordinary ranks of judges into someone who truly has that gift, that commitment, that energy, that open mind. That also shines through. She does not come to her cases with a preconception of how they should end up. So I have to tell you, I was a little skeptical about all the plaudits about her talents, just because I'm by nature a skeptic. And there's a lot of PR in any nomination, but the writings and the opinions bore out every superlative that we heard said about her by her colleagues, by other academics and other judges.
Indeed. I mean, I think one of the happy developments that I've seen during the confirmation hearings, or the chatter on social media, if you will, leading up to the confirmation, is this focus on the judges' credentials. But that hasn't always been the predominant factor that the political pundits or the social media publications have focused on traditionally. Renee, I want to ask you this. In your book, you talk about the fascinating story of all of these women jurists and lawyers. And people have focused on everything else under the sun except their credentials and their written record as a jurist. So what are some of the factors that people have tended to focus on in the past when a woman jurist is nominated to any court, not just the Supreme Court, typically at the federal appellate courts and district courts?
Well, I will say we're even seeing it a bit now, although I wish we weren't, because I agree that Judge Barrett certainly has the qualifications on paper that suit a Supreme Court justice. But I watched those confirmation hearings, and her role as a mother and motherhood was mentioned over and over again, both in terms of describing that as a qualification or a credential, or being sort of rolled off in that same way, and even in questions that she was asked. And I certainly appreciate that she is a mother, but what I will say is that we don't see that same kind of fixation on one's family status when we look at our male nominees. And my point in mentioning this is to go back to your question in terms of how women have been vetted and the way they are scrutinized. This concept of motherhood or lack of it has come up with every single one of our female justices in ways that I don't think is appropriate. So with Sandra Day O'Connor, the fact that she had raised her children already, it was important that she was a mother and seen as a very traditional female, and yet also had the qualifications to go on to become a Supreme Court justice, but also I think important that she didn't have young children at home. And then with Justice Ginsburg, she was described in the media articles, critiqued her cooking skills, and one article said, but she's motherly enough for traditionalists. Again, so when Sandra Day O'Connor was in her final interview before she learned that she would be the nominee, she hosted the president's staff at her home in Arizona and prepared them a salmon mousse. She was, a wonderful cook. And then you have Ginsburg, being described in the media for not. And that has really no relevance or bearing. And then you fast forward to the next women who come to the court, and the headlines were filled with lots of critique about both Justices Sotomayor and Kagan because they weren't mothers. And in fact, when President Obama dared to nominate a second woman who was not a mother, there was quite a bit of pushback. What did that mean for professional women, that you couldn't have children? And now we see motherhood being politicized in a way with Judge Barrett, I think soon to be Justice Barrett, that you'd think at this point in time we would be beyond that, but clearly we aren't. And so I think part of the reason for that is the reality that even though we are about to have a 5th female Supreme Court justice, that's less than 5% of all of our justices over time. We've never had a female Chief Justice. And so the idea of a woman sitting on the Supreme Court or achieving the highest upper echelon level of leadership and power in her field is still relatively novel. And I think that she is going to face challenges that were not dissimilar to what Sandra Day O'Connor faced when she became the first woman on the court, in that O'Connor was very much a token, having to represent everything to everyone. And I think that there will be some of that for Barrett as well. Of course, all of that remains to be seen. As for the other women in my study, they similarly were critiqued either for not having children or for having them, or wondering who would raise them. And I think that just is reflective of the additional burdens and hurdles that women entering professional life are judged by. And one of the strategies, not to get too far ahead in our book, is to think about how caregiving responsibilities can be addressed so that it becomes really a non-issue for whoever happens to be taking on those roles in the home. And I sure hope that the next time we see a Supreme Court nominee questioned in a Senate confirmation hearing, no one will have to ask, even if they're joking, who's going to be doing the laundry in their house.
Yeah.
Indeed. I mean, it's sad in that sense that, the focus is taken away from the factors that should matter in a confirmation hearing. Peggy, I think one of Judge Barrett's more opinions that should have received more limelight, but unfortunately did not in the discussion surrounding the Affordable Care Act and Roe versus Wade, was, I believe, her decision regarding a Title IX case. Could you describe that opinion? I believe that's Doe versus Perdue.
Yes, I'd be happy to. Doe versus Perdue was a case in which she wrote the opinion, and it involves a young man who was charged with sexual assault and went through a thoroughly disgraceful Title IX proceeding that denied him the right to present witnesses and evidence on his own behalf. The Title IX, at least 2 of the 3 Title IX decision makers had not even read the report, which was itself a secondhand report by the alleged victim of this sexual assault. And the 3 people decided it was more credible than anything he had put in, and yet he was not allowed to put anything in. And this is a deeply disturbing denial of due process. What I found fascinating about the case is the hurdles that Judge Barrett put him through. She did not give that guy or his lawyer an easy ride. I mean, there were in one procedural hurdle after another. They'd failed to plead something adequately. Other damage claims were scrutinized and thrown out. And just by the slimmest thread, had he carefully enough pled his case to survive and for her to hold that Purdue had not granted him due process. So it tells you that the judge, stuck to the rules, and when cases often get thrown out for exactly those reasons. You haven't pled a clip correctly or haven't followed the rules, and that's frustrating, I know, to many people, but she didn't give him an easy ride at all. But it's a hugely important opinion. It's now been cited in other courts, and I think it is a decision that is seminal and will, I hope, lead to changes in how those proceedings are handled in campuses across the country.
So it looks like, Judge Barrett was very sensitive to the due process, violations that occur in these sort of proceedings, and that maybe, would you say that's an indication of how she would approach due process issues or these, sort of civil rights issues, Title IX, Title VII issues, when she's elevated to the Supreme Court?
I do think so. I think there is a real concern that justice be done. And this was on a motion to dismiss, so it's not as if she made any substantive rulings on the young man's case, but it survived the pleading hurdles that she gave him a pretty tough time on, and he will be able to present those claims in federal court against Purdue University, which has to be the right outcome given the very shocking deprivations of due process that were afforded him, or the due process that was not afforded him by Purdue University.
And I think opinions like Doe versus Purdue really shed a good light on Judge Barrett, her personality and her approach to judicial decision making. So Renee, let me ask you this. In these stories that you discuss in Shortlisted, there have been certain factors, let's say, of these women jurists who that have led to their success. And one of them is probably, I would describe that as this, intransigent independent streak. Could you describe what was the common factor that led to the success of all of these early jurists that you discuss in the book?
Yeah, I agree with you. I think they all had this sort of fiercely independent streak, that they weren't going to necessarily follow a path that others had before them. And in many ways, one of the things they all have in common is super obvious, but I think it's also very profound, especially because as a law professor, I'm often asked by individuals who are thinking about going to law school, is it worth the investment? Is it worth the time? Should I go to law school? And all 9 of these women, we, in addition to going through whatever vetting had happened for, not all of them were judges, but whatever vetting happened in presidential papers, I've been through their oral histories, I've been through their archives. And so most of these women have given interviews about how they even decided to become lawyers. And the one thing they all had in common is really wanting to have a professional life in a world that was largely excluded to women. And the path they chose to do that was becoming a lawyer. And the power of having that law degree opened up worlds to each of them that were, in some of them, physically prohibiting women. Florence Allen, to go back to her, so she's the first woman to appear on a president's shortlist. The way she ends up in a judgeship at all is because she was an activist in suffrage and campaigned for women's right to vote in Ohio. After that right was secured, she turned around and asked those women to vote for her, and they overwhelmingly put her on the Ohio Supreme Court. And that's where she comes to the attention of Franklin Delano Roosevelt, who in 1934 elevated her to the Sixth Circuit Court of Appeals, the first woman to go onto a federal court of appeals. When she arrived, the news accounts of the day, her male colleagues on the bench, reportedly, some of them fell ill and had to take to bed at the thought of presiding over cases with a woman. There was no bathroom facility for her. They had to obtain federal funds to build an appropriate restroom for her. The entire time she sat on the Sixth Circuit, she was excluded from lunch every day with her male colleagues. They dined at an all-male dining club. She had her lunch on a hot plate in her office. I tell all of those details because it was not that long ago that women were literally not let into the building. And all of the women that were so successful early on in my study, the way they got themselves let into the building was to go get that law degree. And so again, in some ways that's obvious, but also I think quite profound. The other thing I will say about the women in this study is that in many ways they didn't have much in common at all. So if Florence Allen was a huge activist for women's rights, obviously going out and championing the right to vote, other women were very much the opposite. So another woman in the study is Susie Sharp, the first female Supreme Court justice in North Carolina, the first Chief Justice of a Supreme Court, a woman elected. And she lobbied against the Equal Rights Amendment. So in many ways, these women couldn't be more different. And part of why I share that is because often I'm asked the question, you know, are you advocating for more women on the court and in leadership? It should be people who are committed to women's rights. And I love that in the study of women who all rose up early in the profession to be equally qualified for a seat on the US Supreme Court, they represented a whole range of viewpoints, just like men have had a whole range of viewpoints represented for them on the court for decades and decades and decades. So the one thing they all had in common was certainly literally breaking down physical barriers to women by earning their law degrees. But beyond that, they really represented a diverse array of perspectives and life experiences.
Absolutely. And I mean, we see that even in the friendship of Justice Ginsburg and Justice Scalia. And as the opera goes, I'm probably paraphrasing, but you know, they were one in their reverence for the U.S. Constitution. So that kind of collegiality on the court is very important. And as you say, I mean, it's a different dynamic. It's a different type of analysis that informs how a Justice Barrett would perform on the Supreme Court. And you know, looking at these sort of other issues kind of detracts the people from having that kind of an evaluation of her judicial temperament. So Peggy, I want to come to you and ask you, recently, after every term, SCOTUS blog releases their stat pack. It's the statistics of, you know, judicial relationships between the justices. And the interesting thing that came out in this year's stat pack was that Chief Justice Roberts and Justice Kavanaugh were the most likely justices to be in the majority, which indicates, you know, that they might be viewed as swing votes on the court. And Justices Thomas and Sotomayor were the least likely to be in the majority, which suggests that they are sort of leaders in their individual camps. So Peggy, from your analysis of Judge Barrett's decisions, what sort of a justice Judge Barrett would be on the court? Would she be one in a pack? Would she follow? Would she lead? Or would she be, you know, sort of a lone dissenter on certain issues?
That's a great question. And the truth is that the judicial record is just not deep enough to say for certain, because she's only been a judge for 3 years. And we don't have her decisions even on a full range of the legal questions that commonly come before the Supreme Court, much less a pattern with respect to how she interacts with her colleagues. But there are some things you can glean from those 3 years. First, she dissented, I believe, only 7 times, but they're powerful dissents. And one of those dissents in a Sixth Amendment case went on to be reheard en banc by the entire Seventh Circuit, and the 10 judges on that circuit adopted her position. To me, that suggests a capacity for leadership. That's a little unusual for a judge to have a dissent that goes all the way and is affirmed by the full circuit, or at least 10 judges of the full circuit, so early in her career. There were some cases where I thought she might have been a bit of a follower, and I think in those cases it was just in a field that was not familiar to her. And so she, as many young judges do, or younger judges do, they tend to go along with the rest of the panel if it's not an area of expertise for them. So I think my guess, just from what I saw in the confirmation hearings and what I see in her writings, is that she could become a leader. And she has the personal skills to be a consensus builder too. But I don't think she's of the type where consensus is all. I think that if she firmly believed in something, and this shows in her dissents, she would be willing to be the lone holdout if necessary, or be amongst a small pack of dissenters. So that's as well as I can paint that those characteristics from the limited information I have.
Indeed, I mean, yeah, she does have a thinner jacket, let's say, than what Justice Kavanaugh had when he went through his confirmation hearings. He was on the DC Circuit for several more years than Judge Barrett was on the Seventh Circuit. So that kind of reflects on some of the thoughts that you shared, Peggy. Renee, I want to come back to you, and I kind of want to switch gears a little bit because I want to talk about the confirmation hearings that we saw for Judge Barrett as well. So let me start you off, Renee, with your favorite shortlisted candidate.
Oh, sure. Okay. So trying to identify my favorite from the cohort is always tough, but I think, and if someone is in the audience has heard me speak before, I may have identified a different favorite because sometimes I switch it up. But I will say that always included in my favorites is a woman that I think probably most people have not heard of. Her name is Soya Menchikoff. And the reason why I will share that she's my favorite, so she was the second woman to be shortlisted by a president after Florence Allen is considered and not selected. It's LBJ. I don't know how seriously he actually considered her. We could talk about LBJ, but I think he was well known to favor people that had been his friends and he had known well. But she was on a shortlist in part because of who was advising him, Nick Katzenbach from the Attorney General's office. He had taught with Soya Menchikoff at the University of Chicago, where she was the first female law professor. Before that, she was the first female law professor at Harvard Law School. Perhaps more people know who her husband was, Carl Llewellyn. But she, as I studied her, learned more about her, and have spent time in her archives, I can say I think at the time was known to have an equally, if not more, formidable legal mind. And part of why she's my favorite is because in law school, I passed her portrait on the wall every day for 3 years. She was hanging up these huge, larger-than-life portraits in the echoing gray concrete halls of the University of Chicago, up with a bunch of white men. And I never really thought I had anything in common with her. And I don't think I even knew who she was, even though I saw her day in and day out. And then I was surprised to discover, when investigating who had been shortlisted by presidents, that she was among that cohort. And part of why she's my favorite is just for that sort of personal story, because I've gotten to know her, even though I never met her in real time in our lives. She passed away before I started this project. I would count her among one of my strongest mentors, because I have been in her archives. I've held the notes she would write preparing for class. I've seen the exchanges back and forth. She was also the first female reporter for the American Law Institute. And by the way, I was in the ALI boardroom, headquarters boardroom before COVID, or earlier this year. And she's the only woman hanging up on those portraits in that venue as well. So she's my favorite for those reasons. She's also my favorite because, as I said earlier, some of the women in the study were very strong feminists. Others were kind of the opposite. I think she fell in between. Her former students said that she, cared about helping women if they had earned it, but she was not outwardly a vocal feminist in any way. But one of the things she did, among her other firsts, she was the first woman to be the president of the Association of American Law Schools, which is the professional organization that all law schools belong to, as professional organizations do. There's an annual meeting every year. It's where all the law professors go, and it's often a place for opportunities to network, to obtain a job, to obtain a promotion, to receive feedback and recognition for one's work. When she became the first female president, she noticed that women were not attending. And she asked why, and learned it was because of the timing of the annual meeting. It was held the day after Christmas through the New Year. And women, being typically the caregivers of young children at home, especially in that era when there weren't that many women in the legal academy anyway. And so she changed the meeting time, which, might not seem like that big of a deal. It was sort of a ministerial act, and not some sort of bold, feminist move. But she changed the meeting time and moved it to after the holidays. Women began attending, and in fact, it's something that I benefited from early on in my own career as an academic, when I was raising toddlers who are now teenagers. And it was at one of those annual meetings that I won an early award for the work that has led ultimately to Shortlisted. So she's certainly one of my favorites. I think the last reason why I'll say is because it shows the power of remembering these legacies and these stories and investigating them and telling these stories, because they can have real world impact, even if these incredible leaders are no longer with us.
So how do you think the kind of stories that you have collected and the research that you have done, how does that reflect on the kind of confirmation hearings that Judge Barrett had? And are there any suggestions or strategies that you wish to share with our group, with our audience, on how that process can be perhaps more focused on the issues that matter?
Sure. So let me offer just a bit of history here, because I think it's easy to forget. We're so caught up in this conversation right now. There's lots of debate about, is the timing right? Is this being rushed too quickly? Should it be delayed? I think that people fall on kind of political lines in that debate. Lots of discussion about whether she's the right woman to fill this particular seat. Although interestingly, I don't think there was much question at all that a woman would be the nominee for the seat. And, that wasn't the case with Sandra Day O'Connor. Of course, Bush nominated Harriet Miers, and when that did not go as anticipated, ultimately replaced her not with another woman. So at least that was off the table. But just by way of perspective, I think that the same kinds of debates we are seeing around Barrett, they have absolutely nothing to do with her. And it sort of goes back to my earlier point about all of this focus on her being a mother, which really has no bearing on her ability and skill set for becoming a Supreme Court justice. And so lots of conversation and debate, not dissimilar to what I discovered in the archives, for example, with O'Connor. Hundreds and hundreds of letters written from people both championing her and vehemently opposed to her women's organizations. In fact, at the time, the White House was tallying like the number of letters pro and con, and actually there were lots more letters against her than for her. And fortunately, Reagan didn't follow that advice, because I think that she was a terrific female, a terrific justice, and setting aside being the first female Supreme Court justice. With Ginsburg, I think that people forget she was a moderate choice at the time. I mean, her confirmation was pretty uncontroversial. I think it was like 96-3. She was one of the last justices to enjoy less than 10 people voting against her. She was, again, women's rights groups opposed her. Some championed her, but many were also concerned. And we saw the same sort of fixation. And that continued with both Kagan and Sotomayor. So I offer that up because I think we forget, it's easy in this world of sound bites and things move so fast, we forget this history and this context. And as for how we move beyond that in the future, well, I think one thing is for sure, the more women who are in positions of leadership and power, the less novel or interesting or newsworthy that becomes. And so that's certainly part of it. As for strategies that we conclude within the book, sometimes I'm asked the question, well, what can women do? And I think that's the wrong question. I don't think we're at this point in a place where women and minorities themselves need to be taking on more in order to vie for positions of leadership and power. Instead, the question should be, what sort of structural changes can we make, maybe that are very easy, like maybe as simply as moving the meeting time, like Soya-Minchikov did, that allow everyone to compete fairly and equally, and importantly, remove this discussion that becomes very politicized around otherness, whether it's motherhood or just being a woman, when typically a position hasn't been held by a woman, and actually focus on who is qualified for the job, and also the importance of having diversity and seeing a Supreme Court that reflects the public it serves. And by diversity, I mean not just diversity in gender, although, you know, don't get me wrong, I'm very happy to see another woman that will be joining the Supreme Court. But she also offers diversity in terms of geography, which is something that presidents used to care a lot about. Diversity in terms of where she went to law school, and diversity in terms of thought and perspective. And of course, it remains to be seen, but perhaps she will surprise us in other ways. Often presidents think that their nominee is going to vote in a certain way or act in a certain way. And that's the beauty of an appointment like that we give to our Supreme Court justices. They are beholden to no one once they are there, other than the rule of law. And it will be interesting to watch how she carries that out.
Certainly.
If
Peggy,
I could add to that too.
Certainly, yes.
I couldn't agree more. And I think one of the changes that really should be attended to by the media and people criticizing the media, and also the senators themselves in this process, is to stop bringing in the irrelevant things, whether it be who does the laundry, whether it be, this is the first female justice that has school-age children, but nobody seemed so shocked about that when Justice Scalia went on the court. And I think it's very important that we recognize that those things aren't relevant. This goes also to, you know, what videos Judge Bork watched, which was also made an element of his hearings. And I think all of those things are disgraceful. They demean women. I was pleased to see Judge Barrett bristle a few times when it was suggested that she was somehow doing her scholarship to angle for the seat on the court, or that she had made promises to the president, or that she would just be a Scalia clone. And I think she was very composed and is by nature a very composed person, but you could see her bristle. I might also add, just as someone who started my career as a lawyer with 2 young children, when they asked about the laundry, and she said, well, we're trying to get the kids to do their own, and said that isn't quite working out so well. She looked and sounded tired. And I think it was just a moment that the question shouldn't have been raised at all, but it was a moment that showed a very human side to her too. I mean, she's not Superwoman, and I'm quite sure the laundry is not always done. And it's kind of refreshing to hear that, even though I really think it's utterly inappropriate to have those questions at all in any hearing for anyone of any gender.
Yeah, and I think, I mean, in terms of, on your point of inappropriate questions or inappropriate factors, that are brought up in these sort of confirmation hearings. The other sort of inappropriate factor that comes in is by way of omission, because people many times fail or omit the factors that should count. For example, I mean, Judge Barrett has written several opinions on the Seventh Circuit that talk about the administrative state and that are sort of important to the mission of the New Civil Liberties Alliance, for example. So Peggy, has there, in her record, is there any decision on deference doctrines or non-delegation or administrative law that stands out and that has implications well beyond, just the specifics of a case?
Yes, there's a handful. The one I probably liked the best was it's a case called Rainsberger, and she found no qualified immunity for a detective who had falsified allegations in a probable cause order, and she held that that clearly established a violation of the Fourth Amendment. That's great news for those of us who care about holding the government accountable for its actions. She had some other cases. The public charge case that got so much attention actually did involve the application of Chevron, but in a way that was so technical, it doesn't really give a clue as to where she would go on deference doctrines. She did hold in a case called Morales that the Attorney General of the United States opinion was not entitled to Auer or Kaiser deference in the meaning of a regulation. In another case involving the Army Corps of Engineers, she held that the Corps had not provided substantial evidence, and as she put it, no amount of agency deference permits a court to let slide critical findings bereft of evidentiary support. So, and also I mentioned earlier her care in reviewing Social Security cases where she did not hesitate to reverse those administrative law judges. All of those are promising signs, but it's not a deep record. She doesn't have a lot of separation of powers cases, which I think are going to be coming up. And another area of interest to us is delegation. And on that, there's no case, which is not surprising since the Supreme Court really hasn't heard a non-delegation case except for Gundy recently for decades. But she did write a very important law review, I believe it was published at Cornell, that included a discussion of deference. It has to do with habeas corpus. Her command of the historical record on that is astounding. She has probably read everything ever written on it, understands why you can't allow the legislature to delegate its powers to an executive, and that can only very rarely be done. Now, mind you, in habeas corpus, that's a very specialized field, but it shows to me the right instincts and a deep understanding of why it is important that the lawmaking power is vested in the legislature and the legislature alone. So to me, that's a promising point of view, and I hope, because I do believe that deference cases will be coming before the court. And that article shows historical understanding and a conceptual understanding that is very promising.
And that actually reminds me, Peggy, of the sort of litmus tests that we see the Senate Judiciary Committee apply to Supreme Court nominees in recent years. So this would be a question for both of you, but I'll start with Renee. What sort of litmus tests have we seen in recent confirmation hearings, and are they more politicized than in the past, and are they the right tests that the Judiciary Committee should be using?
Well, I think we can look to the votes to say that the process is certainly more politicized, and that we now have a Senate that pretty much votes on party line for the most recent nominees that have been confirmed to the Supreme Court. even so, it wasn't that long ago that we had a president who was still thinking about nominees who didn't necessarily come through their political party. So I think people forget that Justice Sotomayor actually ended up on the federal bench because of President Bush initially, even though it was Obama who put her on the US Supreme Court. And certainly historically, even though ending up on the Supreme Court was always a political process in terms of the maneuverings, right? Like in addition to being incredibly well qualified and meeting lots of professional milestones along the way, there's lots of behind the scenes and connections and that kind of version of politics. It's always driven this process. But to be sure, in recent years, we have seen it increasingly politicized. And also I was reflecting on this as I was watching the confirmation hearings over the past few days and thinking about how there's been so much drama that has nothing to do with the nominees themselves over the most recent hearings, right? So whether it's Democrats feeling that a seat was stolen when Scalia passed away and Merrick Garland never was vetted by the Senate, let alone voted upon, with Kavanaugh's hearings that certainly reminded, I think, a lot of us of what happened with Thomas as well. And now for Barrett, again, nothing to do with her qualifications for the court, but so much drama and focus on the timing and circumstances. And I guess my take on all of that is, and I don't know how we get back there, but one thing that I really appreciated as I was unpacking this uncovered history of women who had been considered for the Supreme Court, simultaneously, I was just revisiting how presidents over time selected their Supreme Court nominees. And I was reminded that there was more thought to diversity. Of course, maybe not the kind of diversity I'm thinking about, like we should have more women in these roles, but at least about diversity of perspectives, whether it's religious or geography, and the kind of background and skill set that one might have had as a lawyer or judge before coming to the bench. And I will say this, in our 9 women, there's only one minority woman, Judge Amalia Kearse. She still sits on the Second Circuit. And she has been on more than one president's shortlist. She was shortlisted by Reagan when he selected O'Connor. But how she ends up in the federal judiciary at all is an interesting insight. And it goes to the question of strategies and thinking about how we select judges generally. President Carter is not often thought of for his role in how he selected judges, but it is one of the things that was a legacy that has endured that he left behind. And when he came into office, only 10 women ever under all presidents had served in the federal judiciary. By the time he left, there were 41 women in the federal judiciary. He did that by creating a commission with panels around the country. Those panels were diverse in makeup, women, men, minorities. They were tasked with vetting applicants who would be qualified, women, men, and minorities, and importantly, made a commitment to diversity a qualification in part of that interviewing process. And Amalia Kearse, who was a highly successful partner in Manhattan, she sat on one of those panels and then eventually was selected by one to go to the Second Circuit. Without that kind of structural improvement, there probably would not have been a minority woman in our study. And I think that reflects the additional burdens and hurdles that minority women still face in trying to move into positions of leadership and power. And so, not that that's the only way or the way we should go back to selecting our judges and justices, but I do think there's something to be said for thinking about more transparency and having a wider cohort of individuals that are both in the selection process and also in the applicant pool as being really important, and perhaps a way that we could remove some of the skepticism and cynicism that has gone into the Supreme Court process now, and perhaps increase legitimacy in the public's perception of how our justices are chosen.
Peggy, same question to you.
Well, I want to start by saying I had the great privilege of clerking on the Second Circuit and having some interactions with Judge Kearse. And one of the things I can report from personal experience was how highly regarded she was by every single one of the judges on her court. And I think of Renee's story of the judges who had to take to their fainting couches when the first judge entered even the courthouse way back in the 1930s. And that certainly was not the case in the 1980s when I clerked at the Second Circuit Court of Appeals. And I think Renee's suggestions are very well taken. I think that it is hard for a woman to progress in this profession. I'm old enough to know when it was considered taboo to have young children in work. And as Renee has also talked about, women who don't have children are seen as somehow suspect, and none of that should matter at all. And in my view, and I think that the process needs to change both in terms of the politics of personal destruction, which you saw glimpses of. Some of the senators were actually critical of Judge Barrett for sitting there, as if she should remove herself from consideration because somehow this process was illegitimate. And I think that was probably pretty hard to take as a part of the questioning. And I think if we could get away from that and focus on, is this an outstanding person who is head and shoulders above the norm and in terms of legal talent, ability, judgment, and all the things that we know is important, we will have come a long way. And I'm pleased that it's 4 women now who've been on the court, am I correct? And 2 of them are conservatives, 2 of them are liberals, and I think that's a good thing. I think diversity of opinion is also important when we make these selections.
It almost seems like the Senate has strayed from its advice and consent role in the kind of procedural antics or the kind of factors or litmus tests that it has tended to focus on in the recent years. I want to remind, before I get to my next question, that if you're a member of the audience, please ask questions. We are looking forward to answering any questions that you might have. But I think we have a question from Mark Chenoweth, our executive director at the New Civil Liberties Alliance. I'll take up his question first, and then I'll ask my question. What insight can you share about how Judge Barrett might impact religious liberty if confirmed to the Supreme Court? I suppose it's a question for both of our panelists.
I'd be happy to start. I think the opinion that stands out is, interestingly, a COVID case where the Republican Party of the state of Illinois brought a challenge claiming that the governor of Illinois' carve out of a more liberal exception for religious assemblies, as opposed to, say, political ones, was somehow a violation of the First Amendment. And she quite correctly joined in an opinion written by Judge Wood that analyzed the First Amendment and, in my opinion, analyzed it correctly, that carving out a special exception for those activities did not violate the Constitution. That's her primary decision to date on that. I think she has written in her scholarship about these issues. I think that protecting religious liberties will undoubtedly be a high priority for her.
And I'll just add to that and say that I think one thing that I have appreciated about both reading her testimony when she went through similar hearings for her 7th Circuit appointment, and then hearing it again from her now, is her assurance that she, as a judge and soon to be justice, has the ability to set aside personal viewpoints and apply the law, maybe even with a result that she would personally not agree with. And so that, of course, can bear on topics related to religious liberty, but also beyond that. And I think that I really appreciated that when I had my con law students watch parts of the hearings this week, that was something that she could articulate. I think sometimes that's difficult for students to conceptualize early on. And then often my students ask me, you know, they can get a little bit cynical reading the way the court has gone, especially over history in constitutional law cases. And so that's something that I appreciate about her. And I hope that that's something that she does, in fact, bring to the bench. It reminds me of another woman from my shortlisted study. Actually, I mentioned her already, Susie Sharp. So she's also one of my favorites, in part because she had led a very colorful life, although on the surface and the way she held herself out to the world, she was very matronly, would give people the advice, women the advice, you can either have a career or you can get married and have children. You can't do both. Behind the scenes, though, at any given point in time, she was caught up in lots of love affairs and had a very, you know, vibrant life, which is a little bit sad that she didn't feel she could merge them both. As I learned more about her, I discovered that she was an avowed racist, that she supported segregation, and that was her personal view. But as a judge, she authored the first opinion to desegregate golf courses in North Carolina. And she said, as a judge, it would not be appropriate for me to insert my personal views into this. And I think that, you know, at a time where, and especially I think because Ruth Bader Ginsburg had become very much a popular culture icon, in addition to being a Supreme Court justice, that there is whoever would come next has all this pressure to be so much more than a justice and representing whatever a particular group is looking for, whether it's something to champion or maybe something to rally against. That Barrett is reminding us what the role of a judge and a justice is. And to the extent that folks are paying attention to this process, I really appreciate that we have a wonderful judge, soon to be justice, and also teacher, professor. I don't know if you caught, it's the last thing I'll say, I don't know if you caught one of the senators asked her some questions about how she might write in the future if she's on the bench, and encouraged her to focus on civics education and taking up that mantle. And she actually referenced the work that Sandra Day O'Connor did after she left the bench in iCivics. And I tell you, that was really refreshing. I think now more than ever, we need someone who can help remind all of us and educate the next generation about the importance of civic engagement and the role of the Supreme Court in our national life.
Yeah, and I would add to that and this goes to the thing both Renee and I have mentioned, that these hearings are delving into so many irrelevant or, in my opinion, illegitimate areas when it comes to a religious test. And I would note that I doubt that Justice Kagan or Ginsburg were asked about how their religion would bear upon their decisions. And that's something we should keep in mind.
So our next question is from Tabitha Kempf. Thank you, Tabitha. Are there notable ways in which Judge Barrett's jurisprudential philosophy diverges from that of Justice Scalia's?
I'll have to defer to you on that one, Peggy. You're the expert.
I could not cite you a case that does that. I do think she has an independence of thought that comes through in both her opinions and her writings. And I believe her when she says, I'm not going to be a mini-me, Justice Scalia. But, you know, one of her more famous cases is a dissent in which she follows Heller in terms of protecting Second Amendment rights. And that certainly was a major decision of Justice Scalia's. And so we can't ignore the fact that there is a similar outlook, and she's going to show respect to those precedents. But I suspect, just from what I've seen in terms of her spirit, that there'll come a time when she will make a decision that Justice Scalia may well not have agreed with. I also would note in the areas of concern to us, which is administrative law and separation of powers cases, that both Justices Scalia and Thomas have evolved. These are people who were very in favor of Chevron deference at one point, and who have now come to question it. And I think that kind of evolution is a good thing, and it would happen with any justice. And if Judge Barrett becomes Justice Barrett, I would expect to see that too, as the issues that come before the court change and evolve.
So I want to quickly wrap up a question that was kind of left open early on, is this question of strategy. So this is really a question for both of you, Peggy and Renee, but I'll start with you, Renee. What sort of strategy should both the candidate who is nominated and the Senate that is about to confirm the candidate be looking for in confirming or not confirming a justice on the Supreme Court?
Well, I mean, I think for anyone who is being considered in the public eye for the Supreme Court, the strategy to follow is to not pay attention to anything that's happening in the media, right? And in fact, I think Judge Barrett said that she has not been following social media. In terms of strategy for the Senate, I mean, I guess it depends on what your goal is. I think the strategy that we're seeing right now is that senators, especially those who are currently up for re-election, are using the airtime that they're getting by virtue of participating in the hearings as an opportunity to make their campaign pledges and promises, right? And that's certainly not a strategy that I'm advocating for. But we're seeing that happen. Going forward, I think that there will be a lot of speculation about reform for the Supreme Court. So, we've heard rumblings, maybe the Democrats will try to increase the number of seats. I will just remind everyone, as a point of history, back in 2016, if President Trump had not been elected, Republicans were saying, well, maybe we should just keep it at 8 justices. We'll try to hold it, we'll reduce the number. So I hope we don't end up in a battle of let's add more, let's take away justices. Although I do think that no system is perfect, and the renewed focus and interest in what's happening at the Supreme Court does present an opportunity to think about potential reform that might be in terms of, and there are interesting constitutional questions about this, but how long a justice sits on the court before they maybe take senior status. And other ways that a president might impose on herself or himself, similar to what Carter did. I mean, he used an executive order to change the way potential appointments for the federal judiciary and the lower courts were made. So there are ways that we can think about building in more public understanding and thinking about the legitimacy of the Supreme Court and the justices who sit on it, certainly beyond court packing. I think that it's a good time when the public is focused on this, and perhaps legislators are as well, to at least look into some of these questions and ask ourselves. And at a minimum, I think that the Supreme Court might contemplate whether, for example, it wants to finally adopt a code of ethics that applies to it. It's the only court, federal or state, that doesn't have a formal code of ethics. And that's not directly related to your question about strategy with respect to the nominee in the Senate, but it kind of all is interrelated, because it isn't just about who the nominee is and who's confirmed, but it's also about how do we make sure that the the perception of the court, the public belief in the court's impartiality is preserved. And that doesn't just begin and end at the confirmation process or the particular justice who was put on the court, but really having those structural improvements in place could give greater public confidence if it was more transparent, for example, when a Supreme Court justice needed to recuse, and also a process in place for perhaps justices who were in senior status or from the circuit courts to step in so that a recusal in the Supreme Court wouldn't end up in an 8-8 kind of, or a 4-4 kind of situation, a tie with only 8. So I think all of those things are part of the big picture strategy that should be contemplated, because the confirmation of a justice is really only the beginning of the process in terms of how the Supreme Court maintains and improves its institutional legitimacy.
Peggy, if I can turn to you in a minute, some strategies for the Senate and the nominee to consider in the future.
Yes, I agree that the recent hearing devolved into campaign speeches to, I think, an extent that no other hearing that I've watched, and I've watched them since certainly Judge Bork's time forward, and that's unfortunate. That's not what these advise and consent hearings are for. But it was also interesting that a number of people, I think of Ben Sass as one of them, who took the opportunity to give the nation a civics lesson on why the Senate was proceeding as it did, and what the history was, and what the reasons for that were, and other issues about life tenure that were being intelligently discussed amongst the senators. And I think we're actually headed into a nationwide tutorial on the Supreme Court. Certainly the issue of packing the court is something that is front and center right now. It's an issue of whether the candidates are willing to commit to a position on that. I think packing the court, I agree with Renee, I think that would be a very unfortunate thing to take place. But there are legitimate reasons to think about how we put people on the court, how we retain them on the court. It is certainly something to think about in terms of capacity to sit if a justice becomes infirm or otherwise unable to rule. I think the ethics rules are important as well. So these are issues, I think, that are going to get a lot of attention, and I think that's a very good thing. And one of the important things I hope NCLA can do, but our nation as a whole, is start to understand the Supreme Court better, how their decisions impact the lives of Americans, and participate, and that there should be electoral consequences as well for the way we handle these appointments and confirmations.
So Peggy, any last words or any cases that you wanted to mention for our audience?
Let me see, I've got my notes here. Yeah, I would say one thing about Judge Barrett. She does not have a lot of experience in mass torts and multi-district litigation and regulation by litigation, which is a particular interest of mine. And over half of the cases that come into the federal courts are in those areas of interest. And she just doesn't have a record on that, and is going to need to develop some competence in those fields, because I do think those things will be coming up and percolating through the circuits. I am convinced, after having read her writings and her opinions, that she has more than enough brain power and commitment and work ethic that she will be able to tackle those issues. But that did not come up in the hearings at all. And just as Adi, you had suggested that some of the deference doctrines and things of interest to us, I believe Senator Ernst did ask Justice Barrett a little bit about Chevron, but that was the only appearance that important issue made in the hearings.
Thank you, Peggy. Renee, any last words?
I'm just really appreciative of the chance to share this time with all of you, talk a little bit about the shortlisted sisters, as I like to call them, and also how they bear out on the way things have gone this week in the confirmation hearings we've been watching. And my hope is that we just see more women go from shortlisted to selected.
Thank you, Renee, and thank you, Peggy, for participating in today's Luncheon Law. We are very appreciative of you here at NCLA. And thank you, members of the audience, for participating as well.
Thank you. It's been great to be with you.
It's a great discussion. I hope to read your book, Renee.
Thank you. Appreciate it.